Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammy. I am Executive Director and Vice President of our Legal Studies Division. We are in our 49th year of free enterprise advocacy and education through litigation and legal studies. We file briefs in just about every court in the country, primarily in the U.S. Supreme Court and the federal circuit courts as an amicus for the most part. We also file regulatory comments on a pretty wide range of issues that impact free enterprise and the rule of law in this country. On the legal studies side, which is what I run, we do publications on the same sort of wide range of issues. We do programs such as this one. We also have a pretty well-trafficked blog called the WLF Legal Pulse. We're at WLF.org if you want to check us out. So in a December 2025 memo issued by the Environmental Protection Agency office outlined a sea change in focus towards a find and fix voluntary compliance approach. In addition, enforcement decisions will be judged by applying 5 factors, which come out to the acronym LEAPS: law, evidence, analysis, programmatic impact, and stakeholder impact. So our speakers today are going to walk you through the agency's new enforcement playbook, elaborate on how the 5 LEAPS factors will alter EPA's approach, and provide guidance on managing risk exposure, making audit choices, and dealing with how states and citizen groups fit into this larger picture. I'm going to introduce our panelists first. Michael Showalter is a partner with ArentFox Schiff, practicing in the firm's New York, and Chicago, Illinois offices. He's a litigator focused on business and public policy disputes, while most of his work involves disputes arising under environmental statutes such as CERCLA, RCRA, Clean Air Act, Clean Water Act. Mike has represented parties involved in civil rights, commercial, class action, toxic tort, and regulatory litigation in courts throughout the U.S. Also joining him today is Thomas Boer. He's a partner with Hogan Lovells, practicing in the firm's San Francisco and Los Angeles offices. He serves as global co-chair of the environmental practice there. He previously served as a trial lawyer at the U.S. Department of Justice's Environmental Enforcement Section and the EPA's Office of General Counsel. Tom represents clients in federal and state environmental litigation, in defense of environmental enforcement actions and citizen suits, in response to catastrophic environmental emergencies and chemical releases, and in connection with site cleanup and cost recovery. I want to remind everyone that we are recording this webinar today. If you have questions for our panelists, please use the Q&A function in the Zoom webinar toolbar. So I am going to share my screen, and they are going to use a PowerPoint presentation along the way. So I will do that now. Somehow, sorry.
Well, I'll start, Glenn, by saying thank you for that kind introduction. I'm certainly excited to be here with Mike to talk about these issues and reading the tea leaves to the extent that we are able to do so.
Me too. Thanks to Washington Legal Foundation for hosting this panel. Compliance First is not simply a rebrand or messaging exercise. It represents basically a structural reorientation of EPA's Office of Environmental Compliance Assurance, enforcement priorities, and candidly, it carries significant implications for the business community, and those are both opportunities and risks. Today, we'll cover the policy architecture, walk through enforcement data, so looking back and see what it tells us, and then turn to the legal and governance implications that should be front of mind for in-house teams and corporate boards. Next slide. Context. Before we get into the substance, let's set the stage. We're operating in a different legal and regulatory environment than we were 2 years or even potentially 2 months ago. 2 years ago, the Supreme Court's decision in the Loper Bright case reshaped the deference landscape. Whereas before, agencies were given some degree of deference by reviewing courts, courts now say, look, if we're interpreting a statute, we are the best interpreter and we're going to go ahead and do it. And that changes the calculus for EPA and regulated entities. At the same time, a year ago, when the Trump administration took office, we saw EPA significantly cut back its workforce and to some degree the funding that both the federal and state regulators used to kind of execute their priorities. And the combination of these two things puts EPA under political pressure to demonstrate results while operating within very, very tight legal and economic guardrails. This tension is sort of the backdrop for what we've got going on here.
Yeah, Mike, I'll just add to that. I mean, I certainly would say that the budgetary issues really, have an important component to kind of how this all, I think, is likely to play out when you look at both the decrease in headcount at EPA and at DOJ and kind of the available funding and even more so where that funding is likely to be targeted within the agency. And I'm sure as everyone saw, I mean, the most recent budget request for EPA from the Trump administration, I think, was around 5 billion, which, historically, I think EPA's budget has been in the more 9 to 12 billion plus range. So that is a pretty substantial change in terms of available resources for the agency. And, again, the enforcement budget has always been a very, very small component of EPA's overall spend, but I do think it shows just the role that the administration anticipates EPA playing and perhaps is kind of an acceleration of the cooperative federalism approach that we saw during the first Trump administration. But now, rather than it being just policy memos, it's really coming through both in the policy memos, but also in terms of resources and more explicit prioritization across the entire administration.
So today's agenda, we've got 3 blocks here. The first is an overview of both what the Compliance First policy says. So that's the December 2025 memo that Glenn mentioned at the beginning, and the core philosophical shifts it represents. Second, we'll kind of walk through the policy architecture, so the LEAPS framework, operational pillars, and the EPA's fiscal year 2025 results. And Tom and I will offer some interpretive caution around those numbers, given when they fall sort of in the overall world. Third, we'll kind of walk into implications, risk exposure management, the audit policies, which the Compliance First policy kind of goes back to, how this factors into state enforcement and citizen suit dynamics, and hopefully provide some guidance for what people should keep an eye on. So Compliance First, EPA's new enforcement playbook. Let's start with the core concept. The Compliance First framework prioritizes returning facilities to compliance quickly and defensively rather than pursuing expensive punitive actions or protracted negotiations. So historically, EPA enforcement was often involved lengthy litigation. When EPA was seeing a facility, EPA would often pursue pretty aggressive legal interpretations, and they would end up in situations when litigation could go on for a long time. EPA is acting quickly and defensively. Defensively, they're doing a ton of work. It signals an awareness that EPA's enforcement actions need to survive judicial scrutiny in a post-Loper Bright world, and the scrutiny there would be exacting. The framework also narrows the scope of remedies and puts a pause on supplemental environmental projects, which historically were used as a significant component of consent decree negotiations. For practitioners, this is a double-edged sword. It both constrains EPA's leverage, but also removes the possibility for creative resolution tools that sometimes served our clients' interests. So why Compliance First matters? 4 reasons. The first is the memo itself is a triggering event. It formally redefines enforcement to prioritize rapid and defensive compliance outcomes over maximal remedies. Second, legal enforcement has changed because courts are requiring creditable agency records and rejecting expansive statutory interpretations, which means defensive compliance isn't optional for the agency. It's essentially existential for enforcement at all. Third, this sort of effectively ends up elevating environmental compliance to board level risk. Compliance historically was oftentimes handled at lower levels of companies, but now if you're advising a board or audit committee, this needs to be on their agenda because the expectation from EPA is potentially for faster responses and more transparent engagement with regulators. And if corporate officials don't have the ability to do that without board guidance, it creates a fire drill. And then fourth, leaders themselves must track inspections, judicial filings, penalties, and no penalty outcomes to sort of align compliance strategies outside of just waiting till enforcement happens.
Hey, Mike, I think if I just want to emphasize, you've said this twice, but I do really just want to emphasize, I think, in terms of Loper Bright, just how much of a difference that really makes in terms of, the agency's weighting of how it's going to decide what to pursue and how much to invest. And in cases, just because, the calculus, I feel like, has changed so much in terms of having to prove that its interpretation is correct rather than getting substantial deference in an enforcement context. And I do feel like, historically, if you're looking back at how EPA would address enforcement in years past, I mean, I would analyze, make an analogy perhaps to like, a snowball rolling down the mountain, right? That, EPA would try to, bring maximum leverage in a good case and then gain some momentum and then try to bring in everyone else, that it thought it had an enforcement case against and continue to get momentum to kind of get settlements. And I think to some extent that's really been pulled out from underneath the agency as a strategy given Wilbur Bright because you can't really gain momentum anymore. I mean, first, I think the first entity that faces enforcement is going to have more of an incentive potentially to decide to test whether or not any type of interpretation underlying the enforcement action can survive judicial scrutiny without deference. But I think even more interestingly, it's also that, even if that company loses, say, in the, District of Massachusetts, it's very possible that in the District of Texas, another company will be like, it doesn't matter because so there's a district court opinion in Massachusetts. I'm going to test this in this other district court. And so, to some extent, you can really see, aside from kind of the philosophical concept of what the agency's role should be in the context of enforcement versus compliance, just from a pure kind of risk calculus perspective, why it is EPA might be really interested in shifting a little bit to try to minimize the consequences of getting bad decisions from district courts in enforcement.
That kind of cuts both ways. I mean, if you think right now, and use the immigration case as an example, EPA has become pretty clear that or not EPA, Department of Homeland Security has made it pretty clear that the only court authorities that they're going to deem to be sort of effective are either the Supreme Court or court decisions which reinforce their own power. And I think you're right. To the extent things get litigated here, we're in a whole different world.
Yeah, well, with a different administration, it could cut in a very, very different direction, I think is a good point too, in terms of companies trying to ascertain certainty on statutory interpretation. So yeah, definitely agree with that.
So on to the next slide. We've got 4 pillars of this policy. They're all worth understanding. So the first is sort of unobjectionable. Compliance is a North Star. EPA is saying the goal is to get facilities back into compliance fast, not to maximize penalties, not to get an expansive interpretation or drag out consociation. Legal precision, remedies must be grounded in clear statutory authority. And I think that comes back to Loper Bright to some degree, but it also comes to historically conservatives' desire to see from a process perspective, everything cut back into the core statutory authority which EPA has. This is a direct response to the post-Chevron environment. Collaborative federalism, we see a renewed emphasis on state coordination and open communication to avoid regulatory surprises. Again, this sort of fits into the statutory framework as it's long been there. And I think to the extent everybody, business, government, nobody really wants any sort of surprises. But for folks who practice in multi-jurisdictional settings, it's an aspiration that's important to keep an eye on. And the fourth pillar, narrow remedies with a pause in supplemental environmental projects. Remedies are going to track closely to violations, but you're going to have a vastly different situation trying to figure out ways that you can settle claims and get sort of meaningful benefits back into communities to address any potential harms that were caused.
Hey, Mike, I'm gonna jump in on the cooperative federalism side, and I feel like I'm obligated to do this as an attorney sitting in California. So, I mean, I think obviously the cooperative federalism is a real thing, and I think there's no question that from EPA's, the current EPA's perspective, that there is a real intent and a belief that it is the appropriate way to pursue enforcement is to the extent possible, to have that delegated to the state level and have, local enforcement with folks who are familiar with local circumstances and the rest. I just think there is an asterisk there, which is I think the agency is going to be fierce in its territory where it feels that states are overreaching or imposing uh, unacceptably broad interpretations of statutes or over-exercising their authority. And we certainly have seen that DOJ, on behalf of EPA, is actually willing to step in and try to rein states back in when it feels they've taken that approach.
Yeah, I mean, I think the litigation sort of in the climate space against New York and Vermont and Hawaii and Michigan sort of represents that. We could talk about that a little bit later. It's a really interesting decision out of the Hawaii efforts recently, but
Yeah.
it gets us a little bit afield from where we are now. So next slide. So how compliance first shows up in the field, here's where the rubber meets the road. The agency is investing in a compliance assistance toolkit, which ranges from proactive outreach, technical assistance, voluntary programs, and self-reporting mechanisms. State and federal coordination is being formalized, but the reality is when we're trying to figure out when EPA defers to states versus reasserting its own authority, it's still a live and often unpredictable question. I was at meeting last week with the acting director of Illinois EPA, and he stressed both that there was at this time, and we've got the sort of very blue state here, that there's not a ton of daylight between Illinois EPA's priorities in promoting industry and EPA's. But in practice, when you get caught up with lower level staff in the agency, you sometimes run into roadblocks. So the federal governments and state governments have open communication channels, which aren't still kind of fully set up. And they're building an inspection and internal response protocols. Once you find a violation, the emphasis is on communicating that to the regulated community clearly connecting any violation to law, and then negotiating any remedies with precision, again, with reference to the overall laws. So from my perspective, companies need really to start thinking about their strategic enforcement readiness now with understanding what their operations look like, what potential issues they might have, and thinking about how their data aligns with what corrective action might be requested, and then sort of escalating any internal issues people see so that people are ready to respond swiftly and in a coordinated fashion if you have an inspection or a notice of violation coming from regulators.
Yeah, I would just emphasize again the kind of the speed with which regulators follow up post inspection or post identification of potential violations is something that I think the EPA has been really struggling with for years, and it's had various guidance that's been put in place in terms of how quickly it's supposed to issue NOVs or respond with inspection reports following inspections, and it has always had some difficulty meeting its own standards. And I think it's one of the things that certainly for my clients is exceptionally frustrating, and hopefully is something that the EPA will continue to focus on under this framework, which is, if you have an inspection, you actually are going to hear back from the agency with feedback and be able to have a dialogue with the agency rather than wait around, for 6 months or a year or sometimes even longer before you get an inspection report or an NOV, which I think that a lot of facilities and a lot of companies find to be very, very frustrating.
So, and what that dialogue is going to look like is going to be shaped by what EPA has called its LEAPS framework, which is actually on this slide. I think I had my notes off a little bit here. LEAPS stands for Law, Evidence, Action, and Programmatic Impact, and also evaluating stakeholder impact. On law, the agency is committing to the clearest, most defensible statutory interpretation supported by legal text and precedent. So that's sort of the best interpretation of the law, is referred to in Loper Bright. On evidence, EPA wants gold standard factual support. So rigorous monitoring, data integrity, thorough investigations internally. So if you're on the receiving end of an enforcement action, this is sort of good news. It means the agency's evidentiary burden on itself is higher. Lots of us had fear historically, as you see, the cost of environmental data collection monitoring has gotten to be really cheap. but the standard of the data coming out of some of those monitors has always been open to question. I mean, what I take this to mean here is that EPA is really looking for seriously technically grounded data and not just any available data, and trying to figure out what's going on at a facility. The A is for action. So they're looking for proportional remedies linked to any violation. And the P and the S stand for programmatic and stakeholder impact. So EPA is telling its enforcement staff to consider broader effects on industries, states, and litigation risk against EPA itself. So sort of as Tom emphasized before, this LEAPS framework is sort of where you're going to start in any negotiation. And folks are going to need to try to hold the agency to its own stated standards. Anything more on that? Oh. So how compliance first shows up in a field, we've talked a little bit about this already. EPA's built a compliance assistant toolkit, that's outreach and technical help and voluntary programs. So EPA wants to engage in early dialogues with regulated industries about issues they're seeing and get self-importing with intents to correct instead of just waiting for enforcement. State and federal coordination, Tom's talked about this a bit. We're still trying to figure out when EPA is in the lead and when states are in the lead. Open communication and governance. Look, once you have a centralized inspection and you're going to see data, the EPA wants to see regulated community being willing to negotiate and talk about issues to avoid surprises on the regulators. And then leaders need to prioritize being ready to correct any issues or any violations that are noted. Anything more on that one, Tom?
I mean, I think we talk about, I have more to say about self-reporting, but I think we can talk about it further down when we get into some of the takeaways. So yes, I think, so nothing more here.
Sounds good. Next slide. Yeah. So enforcement data and competing interpretations. Next slide. So since the framework was announced, we got EPA's fiscal year 2025 data. And what we saw were more enforcement case conclusions that had been started in 9 fiscal years. We saw the second highest amount of compliance monitoring in the last decade. We saw the second highest amount of site inspections in the last 8 years. And we saw the most criminal defendants charged since fiscal year 2026. So EPA's fiscal year 2025 report, which was released during the Trump administration, shows us sort of at the high water mark for site inspections. But these numbers relate largely to things that started to happen or were in process by the Biden administration, which wrapped up during the Trump administration. So even though we've seen more than $6.4 billion in costs, EPA secure things, commitments to return facilities to compliance, and tons of voluntary disclosures and new audit agreements, it doesn't necessarily mean that that's stuff that's happening right now. These are results of actions that were probably largely put in place by the administration before.
Yeah. I mean, I agree with that. I mean, I think these are incredibly interesting results, but it's hard to tease out kind of what it's going to mean in terms of the trend line over the next 3 years, particularly with staffing issues. But I do feel like that almost regardless of the trend line, right? I think some of the message that's important in terms of the takeaway is that, I mean, EPA is still out there doing enforcement and doing inspections. And I feel like sometimes, I'll have clients that express some surprise that actually is still occurring, but no, it is actually occurring. I think that the trend will be interesting to see like I said, over the next 2 years or so, especially because, for a lot, not for all, but for many, particularly more complex enforcement cases, generally there's going to be, a year, 2+ years in terms of case development and kind of the internal process at EPA before you're going to start to actually see an enforcement action result from it. And then on the inspection side, I think it will be interesting to see what develops with a number of inspections. I mean, historically, EPA has farmed out quite a bit of inspection authority to contractors. So, it's a little bit unclear, at least to me, when you're looking at some of these budgetary numbers, like I was talking about before, that doesn't necessarily mean inspections are going to go down, both because per se, both because in terms of the amount of money that the inspection program costs versus, the total dollars EPA has, regardless of how big a budget cut is, it's really not that much. And also because even with lower staff, it is possible for inspections to be done by contractors. Um, so I think this next coming year's enforcement report, I think will provide a lot of context in terms of how this will develop during the remainder of the administration.
Yeah, and I think one other thing that's important to note is we have seen the costs of monitoring go down. And because the prior administrations have a lot of sites under consent decrees and things to gather more data than we had before, looking at data because of the rise of artificial intelligence and the fact that a lot more data is publicly accessible than it was before means that the cost to actually do an inspection may not go down at all.
Yeah.
So I think that's important to keep in mind. Next slide. So looking back over the past 10 fiscal years, so from fiscal year 2016 to fiscal year 2025, the monitoring trend here is important for context. Compliance monitoring declined from between fiscal year 2016 and fiscal year 2020. COVID there was an obvious driver, but rebounded between 2020 and 2025, reaching over 14,000 activities. So the insight here is that high monitoring intensity can and will continue under a compliance first approach, even as enforcement remedies narrow. And some of that is the point that I just made, that we have a lot more data that's accessible and the cost to look at any individual instance of data has gone down dramatically. So what does that mean in the field? It means detection risk is elevated. Companies themselves need strong data quality, rigorous record keeping, and rapid response capabilities to deal with any instance where their data is sort of out of line with legal requirements. It also means that companies need to sort of think a lot about when to voluntarily disclose and sort of engage in proactive corrections, because that's what compliance first is really stressing. If you see a problem, identify the problem, tell EPA about the problem, and come to them with a trend to get rid of it, because that's going to keep you out of the potential of having sort of enforcement filed against you.
Yeah, and on this one, I just want to emphasize kind of how much things have changed in terms of what EPA is doing. I mean, I feel like it was ages ago now, Mike, but remember next generation compliance? So, I mean, I feel like it's a completely different approach here, from where EPA under next gen, was really looking to impose essentially advanced monitoring and kind of reporting, public reporting obligations above and beyond regulatory and statutory requirements, via consent decree and enforcement settlements. And I think that, this whole approach the EPA has announced really is kind of a return to the basics and away from that type of next gen approach that we've seen previously from the agency. That being said, I do think one of the interesting things, particularly with AI, is that from from the public's perspective and from potential citizen suit perspective, it's probably getting easier every day and has never been easier than it is today to kind of use AI in order to either analyze publicly available data or to pull publicly available data from different sources. So, to some extent, ironically, you're not necessarily seeing the imposition of kind of this next gen approach coming from the agency, but the accessibility of the data and using it has probably never been easier. And then the other part, I think, is on the self-disclosure and self-reporting. And I would just really emphasize that, which is that, now is certainly the time to be thinking seriously about making reports and self-disclosures. And I know that I have kind of heard from some clients who are like, well, do we really even need to do a self-report, self-disclosure? How likely is it's going to be, issues are going to be identified or we're going to be inspected? But I think that this is certainly the environment and the time to think seriously about doing that. And I heard Todd Blanche speak, so kind of from the DOJ's perspective, last week. And, DOJ's perspective was, again, I think consistent with EPA, really wanting to support and emphasize how much the Department of Justice was in favor of companies doing self-disclosures, and that they would not be penalized for coming forward with a self-report, and hopefully would actually, get a real benefit of the doubt, which I think has always been um, the hope or anticipation of the self-disclosure and audit policy, but has not always been exactly how it's played out in practice. So.
It's, the federal rules, the Federal Rule of Civil Procedure 1 wants the just, speedy, and inexpensive resolution of disputes. And I think EPA's pursuit of enforcement litigation oftentimes may have focused too much on just from their perspective, because environmental enforcement, in my experience, has almost never been either speedy or inexpensive. And this may just be, a pretty effective way to reprioritize that. Because what you're doing is saying, okay, there's a problem in the field. We're going to identify it, and then we are going to get it remedied and then move on. And that provides good incentives to everybody to work together to sort of help fulfill the purposes of our federal environmental laws. Next slide. So this somewhat harkens back to 2 slides ago. So I think when you look at enforcement data, you need to look at it through 3 lenses. One, volume versus leverage. Even though case counts right now might be on the rise when deterrence indicators fall, you can see the EPA is deploying its enforcement leverage differently. Second, pipeline effects. Enforcement outcomes lag behind the inspections and investigations that produce them, which makes it very difficult to attribute current outcomes to current policies. Third, and perhaps most important, the mix matters. The composition of enforcement actions, and not just the count, determines their impacts. No penalty cases, for example, still generate real operational and reputational effects. So reputation to the people who are cleaning up an issue that they themselves identified and cleaned up. And so, don't, as Tom just indicated, don't let your clients be lulled by a compliance-friendly narrative. A no penalty outcome can still cost millions in operational adjustments. If there's an issue with your factory and it's a big factory, getting it under control itself is not necessarily going to be a cheap fix.
Yeah, the other part that I would just emphasize in terms of thinking about kind of the enforcement pipeline for everyone just to remember, right, is that for almost all environmental statutes, there's a 5-year statute of limitations. So anything that's happening today at a client's facility, the statute of limitations for bringing an enforcement action on that is not going to run until the next administration is in office, whatever administration that may be. And data that you're collecting today and that you may not report to EPA, until the end of the year or early next year, the statute of limitations will extend even further into the next administration. So, again, I think it's important, to be looking at what the current EPA policy is, recognizing that there may be, there may be changes in EPA policy in the future, and thinking about how to kind of maximize EPA's current policies, to ensure that you get fair, just, and speedy resolution of issues to the extent you identify them now, rather than thinking you can just wait till later in order to address an issue.
Tom, we just got a great question on the chat. Let me read it to you and get your thoughts. Is EPA's April 20th announcement of a filing of a complaint against DC Water for its recent massive wastewater spill to the Potomac consistent with the compliant first approach? Or is this a situation of a special or extreme failure that EPA is responding? Would you expect a comparable event to private industry like a rail car spill to be handled similarly? Thanks. So how do you balance sort of compliance first with sort of emergency events? I think either a wastewater spill or a rail car, I think those are great examples. So what do you think?
Well, I think this is a really great question. So first of all, I would say that generally catastrophic incidents or spills are most likely under any administration to result in enforcement response, partly because of the public perception issue and kind of the pressure for the agency to be doing something. I think that, that being said, I think it also is really going to depend a lot upon the particular incident. And whether or not, EPA believes that it is a result of an unfortunate situation or a accumulation of problematic decision making. So using DC Water as an example here for wastewater, I should say I'm not super familiar with this case. I am familiar with these types of cases, however, and generally, a big component for sewer spills, and whether it's a combined or separate sewer system, is going to be the amount of infrastructure investment that's occurred over time. And so a spill of this size often, uh, one of the issues that an agency is going to look at is, have you basically been investing enough in your system over time in order to prevent this type of spill? And I think in a way that does kind of dovetail with the compliance first concept, which is that the agency's conclusion is that this spill is the result of what it believes to be, years or, decades plus of underinvestment. You kind of missed the opportunity for compliance, resulting in a catastrophic incident, and thereby resulting in some inclination for enforcement.
I mean, it's sort of two things. On the DC water spill, it's also a really hard issue because wastewater infrastructure is really complicated, and to do a fix to present a CSO, so a combined sewer overflow, those are billion-dollar problems oftentimes, because what you end up having to do is reroute and reconfigure your water system in ways that could cost billions of dollars. So that's a really hard issue to remedy in the short term. So you're likely to still face enforcement in that complex. Now, Clean Water Act enforcement in that context is really hard because oftentimes every water agency forever has committed to things that are very difficult to deliver in practice. And sort of non-compliance under the Clean Water Act has been, in the 50 years since it's been passed, it's been a persistent problem. Now, that said, we've also seen dramatic changes in sort of our particular urban waterways. I live in Chicago, and our Chicago River is in 2026 a treasure that we all spend time in, and people swim in and kayak in and everything else. And when the Clean Water Act was passed in 1972, it was a fetid industrial waterway. So, the progress there can take time, but that doesn't mean you're not going to see EPA react. And then in response to the railcar question, one of the first actions that Lee Zeldin did when he took office was to go to East Palestine, Ohio with J.D. Vance and said, we're committed to addressing this. So, I mean, I think if you have a railcar spill in an area, I think, the optics of that are something that EPA is not going to ignore. I think it's still likely to represent a similar sort of problem as it would have before any other administration. People don't like those optics. The optics are not good politics. Whatever this policy was, it's an emergency response, and EPA is still going to act aggressively in that space.
Yeah, and just to emphasize the 1.2, Mike, about the complexity of these systems and the costs, it is also another reason that drives enforcement that I think even, the current agency isn't going to be interested in this context, which is that, they want a consent decree because they want basically for these types of sewer spill situations, because they want a binding agreement to implement, these large infrastructure projects that take years to occur. And so really the most effective way, I think, for those types of projects is via consent decree. And I think it is a little different than a lot of other agency type enforcement. And frankly, and again, I'm not familiar with the DC water action with specifics, but what I would strongly suspect is probably there already were ongoing enforcement discussions over compliance prior to the spill. So it's not like the spill occurred and EPA showed up with no information and then decided, to refer a complaint for filing. But this is probably part of a long-standing discussion between the agency and DC over its compliance.
We got a question on 2026 data, which I think we should address right now. I have looked at the data. The question implicates that there's been a big drop in enforcement during 2026. I think that's really kind of no surprise. 2026 has seen a ton of disruption due to lots of people leaving the agency voluntarily and involuntarily. We've seen the agency sort of just setting up the deck chairs. This policy itself implicates that you're going to see some sort of drop off in enforcement. But I think just the context in which this policy, came out, you're going to have a drop off for enforcement probably anyway, just because of a drop off in EPA's headcount.
Yeah. Well, and that is, further exacerbated by changes at DOJ as well when it comes to enforcement that's being referred for civil enforcement in the courts. I mean, I think that The environmental enforcement section at DOJ, I think, has dropped from probably around 150 attorneys to, between 50 to 60 attorneys at this point. So, I mean, you have some institutional constraints, like you were saying, Mike, in terms of what can be brought. Now, what I would say, how I think EPA almost certainly would respond to this, and I feel like I probably have actually heard them say this, I just can't put my finger on it, is I think they would say, well, but you can't just look at EPA's echo data because but in doing that, you are completely glossing over the importance of cooperative federalism. So unless you essentially look at aggregated enforcement data from states and from EPA, whatever trend line you're seeing is not really showing essentially what the full enforcement circumstances are, across the country. And I think that, EPA's perspective would be they really expect that states are going to step in under the cooperative federalism approach in order to um, uh, uh, to deal with areas where EPA now is not pursuing as much and is focused perhaps more on compliance.
Glenn, next slide, and then skip past this one. So legal governance and strategic implications. Let's shift now to the implications that are driving the strategic decisions here. So separation of powers and enforcement discretion. I feel like this slide is probably particularly appropriate given where we're talking. This is a constitutional law slide, and for those of us who've been following Loper Bright and its aftermath, this is where things get interesting. In the post-Loper Bright environment, agencies face enormous pressure to defend their statutory interpretations on the merits, which is producing more cautious enforcement, but also increasing litigation risk when the agency overreaches. The major questions doctrine and non-delegation concerns, which are still out there, mean that when enforcement actions that effectively expand the scope of a regulatory program without clear statutory authorization occur, they're vulnerable to court challenges and political backlash. And this is subtle but important. As EPA shifts from civil filings in federal court to administrative resolutions, we're getting fewer judicial opinions that articulate the limits of agency authority. That's concerning from a rule of law perspective, and it's something probably worth talking about a little bit here. The takeaway for practitioners: build strong administrative records as if every matter will be litigated, and understand that monitoring inspections are going to continue aggressively even under compliance first banner.
Yeah, I'm gonna go just a little bit off track, so I guess don't let me go too far in this one. I'm sure, Glenn, I'm sure you'll pull me back too. But I mean, it's the major question in non-delegation issue, I think, is just a very, very fascinating issue when it comes to the role of federal environmental regulation. I mean, I think that historically, Congress was more than happy to kind of punt on addressing the specifics of a lot of environmental statutes and let EPA make those decisions. And, one can argue about whether or not that is, and literally that is what the court has done via the major questions doctrine, is whether or not that's constitutional. Also, whether or not that's a good approach to policy. And I feel like that those kind of theoretical arguments that in the 1990s and early 2000s were kind of being kicked around have now become legal issues via the way the Supreme Court has looked at these doctrines, and I do think it's going to have some real long-term implications for how environmental regulation is developed at the federal level and how in the future enforcement progresses. Similar, like you said, Mike, to how this policy is developed, which is kind of a back to basics and like let's find the bright line. Very, very clear statutory authorization from Congress where we were expected to take action and not basically push into gray areas and the rest without specific direction from the legislature.
Yeah, I mean, another thing that's worth noting is if you stack up West Virginia versus EPA, Loper Bright, Learning Labs, and the student loan cases, there's a fair amount of uncertainty as to what things are going to be found constitutional, which aren't. I think the most conservative approach was if you have a new statute, you could assume that EPA or any agency going to implement it is supposed to implement that statute to its maximal sort of concerns now. And if it doesn't, any sort of new use of an old statute is going to be viewed with some skepticism. Building out from there, I think things get hard. I think they get more difficult because since at least for the past 15 years and probably for the past 25, particularly in the environmental context, we've seen a lot less new statutory law. And the problems that the world is looking at and how they're looking at problems is changing all the time. And I don't know that it's changing necessarily in a liberal or conservative way, but issues like energy transition highlight the need to aggressively look at our statutes to say, how do we build linear infrastructure, for instance, faster? And when you straitjacket those statutes, it leaves you into situations where bargaining things through Congress in the current moment is very difficult, but it's tough to figure out how to balance this. And I think you can even see the current administration kind of struggling with that in regard to NEPA reform or AI development of facilities. And all these are things, and they're tough questions that everybody's struggling with, and it's not necessarily a liberal or conservative issue. Anything more, or on to the next one? We're trying zealously to keep us on track here.
Yeah.
So EPA's audit policy. The audit policy is a powerful tool that I think almost anybody who's encountered it believes is somewhat underutilized. And under Compliant First, it becomes even more strategically significant. The audit policy has 9 conditions in it, and if they're all met, it can eliminate 100% of gravity-based, so sort of serious-based civil penalties. And even if all the conditions in it are not met, you get significant penalty reductions anyway. On the criminal side, a good fit disclosure under the audit policy, along with correction and prevention of future issues, can get significant prosecutorial relief. For any transactional lawyers here, the new owner audit policy is critical in M&A because it allows acquirers to reduce post-acquisition environmental exposure. Strengthens leverage in deal negotiations because if you're taking on a new facility, you can look hard at your facility and kind of get rid of everything in one fell swoop. From a governance perspective, having kind of in place council-led audit frameworks with rapid response processes and board recording can really help create systems that can help identify, disclose, and correct violations consistent with Compliant First and audit policy timelines while sort of protecting legal privilege. Here's just a scenario to figure out how this plays out. A newly acquired subsidiary of a company has a history of RCRA reporting gaps that surfaced during integration post-closing. Under this new owner audit policy, the acquirer has a window to self-disclose and correct, eliminating potentially all of the penalties. But that window is going to require the deal team and environmental counsel to figure it out pre-closing this as a risk. The board of the acquirer being ready to approve whatever corrective protocols in place, and the compliance team to go out and execute whatever environmental remediation is required under a very short time frame. So if you look at this as a punch list item, that's a problem. But if you look at it as a governance priority, you can get it done, and you can get things done in such a way that you can take tons of risk off the table. So, that's sort of a thinking failure and not just a compliance failure.
Yeah, I said this before, but I'll say it again, which is I just really think that now is the time for companies to be thinking very seriously about conducting audits and trying to take advantage of the audit policy. And Mike, like you said, I mean, there are different audit policies. So some of these are just in connection, for example, with acquisitions of companies, and that's kind of a circumstance specific. But you certainly can't conduct a third-party audit of your facility and potentially decide to self-report violations that are identified. And I just think this is certainly a point in time where it makes sense, I think, for folks to think seriously about that. I think that some in the regulated community feel like, well, if inspections are trending down, if enforcement is trending down, like why would we spend the money and the effort to kind of go do this? And I think that is an erroneous conclusion for some of the reasons I said before. I mean, first of all, there is still some enforcement. There's still state enforcement. You still have an obligation to comply with laws as I think a matter of good corporate citizenship and protecting human health and safety. Now is really an opportunity potentially to take to implement the intention behind the audit policy. I'm gonna, in a shameless shout out though, I will say that if there is anyone from EPA who is watching, it would be very nice for them to take a look at the audit policy, particularly when it comes to the turnaround time on timing for reporting, which I think has always been one of the most frustrating requirements, to have to act so quickly to self-report. And I mean, I honestly think that it is disconnected in a bureaucratic understanding sense from the reality of how companies operate. And even companies that really have an interest in taking advantage of the audit policy for, with real good intent, that timing framework can be very, very difficult because usually, in order to kind of raise your hand to EPA, most companies are going to require that to go to a pretty high level within the company hierarchy, and that takes time to explain the risk, to get the people briefed from the point that something is uncovered or discovered. And I actually think it makes audit policy and compliance less effective. So I would argue that, a 90-day time period, for example, for reporting under the audit policy without losing its full benefits would make a lot more sense and would probably result in more compliance and more self-reporting than kind of the more strict timelines that are currently in the policy.
And thereby a cleaner environment, right?
Yes, right. Accomplishing which is what to be really clear, and I think there's tension on this issue, right? But that is what the audit policy is really trying to accomplish, is EPA cannot inspect every single facility. I mean, even an extremely highly funded EPA cannot inspect every single facility. And so, the trade-off in the audit policies, we're willing to forego some amount of penalties in return for essentially the regulated community doing the job that they should be doing from EPA's perspective, but also the job that EPA just functionally cannot do. And the end result is a cleaner environment, increased health and safety, and I think those are laudable goals. Yeah.
Yeah. Next slide. So, what to do now? We've got 4 action items, and we'll be direct. One, and I think Tom discussed this, you got to have a rapid corrective action playbook given sort of the timeframes you're working for. So that sort of implies pre-built protocols for quick diagnosis, correction of violations, along with reporting and requirements. So you're not scrambling if you figure out that something, it's a problem happen. Second, invest in documentation and defensibility. Anchor every compliance position and regulations and statutory law, document reasoning, and create a credible record that'll hold up during inspections and in any administrative or civil litigation. Third, empower legal counsel to escalate and address inconsistent regional interpretations of the compliance policy itself. Because compliance first is centralized doesn't mean that implementation isn't going to break down across regional variability, and that's going to result in operational risk for companies. Fourth, align audit and disclosure programs strategically, so coordinate timing, manage privilege, and account for jurisdictional overlaps between federal, state, and citizen suit exposure. So, Tom, let me outline a scenario for you. Consider a multi-state manufacturer operating facilities in states like yours with aggressive and independent enforcement programs. The CEO of this company gets a briefing that EPA has adopted a compliance-first posture and concludes that the regulatory temperature has cooled. But your state AG's office has its own enforcement priorities, and citizen suits are out there monitoring a facility of your company and see a violation in discharge data. If the company self-discloses to EPA under the audit policy, I mean, what's likely to happen with the states? Could the states and the NGOs still file independently, or is there going to be any way under this to get a shield from by the federal authorities?
Yeah, I mean, I think that there are absolutely ways to get shields, right? But I think it ultimately is going to depend upon how a resolution is worked out with EPA. So, I mean, I think that realistically, in most instances, you probably are going to need a consent decree in order to get a shield from citizen suit enforcement or from a state AG action. And a consent decree obviously is going to be higher profile, and it's also going to probably require public notice. So if this is something that is, this is something that's particularly controversial, you need to be aware that, getting a consent decree entered might take some effort. So, I mean, again, to be clear, I mean, just because you use the audit policy to report to EPA, it's very possible, for example, EPA could come back and say, we really appreciate the report. We're not going to take any additional follow-up action. And that could be a great outcome for some circumstances, but in other circumstances, that might not be ideal if you're particularly worried about a citizen suit enforcement or an AG action. And you would need to work with EPA in order to think about how to address those issues. I think one of the big questions that's out there is the citizen suit risk and what is going to happen on the citizen suit side, particularly as you know we've been saying, if federal enforcement uh, uh, declines over the next several years, and particularly if state enforcement doesn't kind of fill that gap, um, are citizen suits, and most federal statutes certainly allow citizen suits, going to step in and increase. And it's an interesting issue in that certainly there's, I think, more funding and more resources available to environmental groups. But the real question is how much of that goes to suing the Trump administration on policy issues versus how much of that goes to kind of citizen suit enforcement. And that's where it becomes confusing from an individual company's perspective, whether or not your risk of a citizen suit enforcement actually is going to increase given some of these changes.
Yeah, I mean, I have to think, at least in my experience, even if you had a very aggressive enforcement-minded federal regulator, you're generally better positioned to negotiate with the federal regulators than you are with a lot of environmental NGOs.
100% agree with that.
Uh,
Um, I'm sure we could tell we don't have the time, but I'm sure we could tell some more stories on the basis for that conclusion. But I share that conclusion entirely. And I will let me just add though that I will say that not always, but on the state AG side in the scenario, Mike, that you gave, I mean, if you did self-disclose to EPA and you didn't enter into a consent decree, but you either paid some type of administrative penalty or there was some type of record in terms of how the issue was resolved. I mean, I think a lot of state AGs, except on kind of the tail ends of the bell curve, are likely, even under this, even where there's a dispute between, the ideological perspectives of this administration and the state AG, are likely to defer to that in most instances. Because are those the cases where the state AGs want to basically spend their resources versus pursuing cases where there has not been a self-report and where, there hasn't been any type of resolution? So.
it's funny because it sort of turns over filing is the term for when you've negotiated something with a state and the feds come in. But the risk here is you could have an overfiling of, state people over a negotiation with the feds. And I agree. I think sort of structurally that's a little bit less likely. Let's go on to the next slide, and then we'll leave. If there's any questions that anybody has, please feel free to let us ask them. So
Now's the time for the questions. Type them in.
let's close with what keeps environmental lawyers up at night. Implementation variability is the biggest near-term risk. While compliance first is a centralized policy, you've got EPA regional offices and state agencies who might implement it different, leading to inconsistent outcomes. And patchwork environmental enforcement is real. State level enforcement can and often is stricter than federal requirements, particularly in the current political environment. And that creates a fragmented regulatory landscape with higher costs for multi-state operators. Political selectivity and uncertainty are inherent sort of in the framework that we're existing in. Enforcement priorities will shift with administrations. And as Tom emphasized before, it's likely that any data collected right now could be used by subsequent administrations. And, the current sort of compliance first policy might not survive the next election cycles. Finally, we have folks here asking questions about the ECHO data. So it seems like we've got a data tracking crowd, inspection rates, judicial complaint filings, administrative filings, referral trends. Those are probably better things to look at than annual enforcement summaries, which are generally lagging indicators at best. So thanks everybody for coming today. We really enjoyed the opportunity to talk to you, and thanks Glenn for having us.
Well, thank you both for joining us today and for everyone as well. I want to ask a real quick question, seeing that there aren't any from the audience in addition. So if the reading the tea leaves is correct and the Democrats take over the House, would you imagine that there will be John Dingell-esque hearings being convened by the Energy and Commerce Committee and the Oversight Committee and others, hauling EPA officials in there and browbeating them for this more voluntary risk, and basically turning it into a, oh, you're just letting the companies do whatever they want sort of perception.
I am going to be contrary, as I often am, and I think that that is less likely than one might expect. I do think that there will be sort of oversight hearings in that circumstance related to other agencies, but I think that there may be hearings touching upon things like climate policy. But in terms of enforcement, in terms of sort of statutory focus of EPA agency officials on sort of agency priorities, I think a lot of the priorities that people are really focused on right now are sort of bipartisan. I think permitting reform is likely to be a focus of anything in Congress. I think that's an issue that has long needed some focus, and I think people in the agency are kind of aggressively trying to deal with those issues. Now, you might disagree with how they're doing it, but I think everybody or a broad selection of people think that they're focused on the right thing. New chemicals, I think, is another area where there has been a broad sort of belief that EPA needed to deal some things, and some of that's just a function of when the Lautenberg Act passed 10 years ago. But I'm not sure necessarily outside of general specific instances that's super likely in this context. Tom, what do you think?
Yeah, I mean, I actually am surprised, Mike, that I agree with you on that one. I just think there's so many issues that a new Congress would potentially want to get into, and a lot of them being, very not being general, but very specific. Like I imagine there might be hearings, for example, on some of the decisions regarding, distribution of green infrastructure funds and kind of how those decisions were made. But in terms of general enforcement, I think that honestly is not going to be the highest priority. Where I think the only place I disagree is where it may change is if it becomes a political issue where there are kind of higher profile hearings. So if there's an incident, for example, that occurs with consequence, and then basically the question becomes, well, can there be a hearing basically saying that the incident, explosion, release, whatever occurred because of a lack of environmental enforcement by the agency and kind of using that as a hook. So, certainly I think we would all hope that there are not incidents under any circumstance, but that's where I think it would most likely come up, at least in the course of the next, 1 to 2 years.
Yeah, that makes sense to me.
So also on the citizen suit side of things, there's an issue that comes up where EPA or states have been active, the so-called diligent prosecution defense. How are courts going to look at that, you think, where citizen groups bring suits in situations where EPA has taken more of a voluntary approach or entered into a consent decree?
I think we're going to end up in situations where courts look pretty strictly at sort of the language of the statute. So the diligent prosecution bars are sort of instances in their specific language in each of the environmental statutes, kind of saying what has to happen to bar a citizen suit. And I think sort of you're not going to have deference, right? I mean, it's a jurisdictional thing, and the court itself is probably best situated to determine whether the conditions that are set forth in that statute are met. And I think both, I think it's going to be less likely that EPA is going to stretch the diligent prosecution bar. They may try to help other ways, and you may be able to use whatever you got with EPA to defend against the suit, but it's going to be challenging.
Yeah, I mean, all I'll say is it's a resource issue in a huge way. I mean, it is so difficult for EPA to act in a, even with the best of intentions or desire to act in, in a timely manner in order to really trigger the diligent prosecution bar. Um, so I just, because it's a common question from clients, right? Which is, we just got this 60-day notice that, these guys say that they're going to sue. And so, can we go to EPA and get a settlement because we think this is so unfounded? And in practice, I think accomplishing that is very, very difficult just because of the timing constraints. That being said, I mean, there are interesting, there are interesting developments in the law, and I'm forgetting the Ninth Circuit case now that just came out in the Clean Water Act. right, but which really indicated that kind of the Gwaltney limitations for Clean Water Act enforcement continue after the filing of the complaint. So essentially, at any point that you can show you've cured all of your ongoing violations, that you have a basis for dismissal. And that certainly is a real potential limitation on citizen suits. Um, so I think that I think there are ways, I think, potentially to manage some of those issues.
So we'll finish up with one more question from our audience. Are all EPA regions aligned with headquarters on the new compliance policy, or have you seen variability?
Well, I mean, I guess what I'll say is that, from a unitary executive perspective, the answer is absolutely they have to be. There's no alternative. They're all led either by EPA confirmed regional administrators or by acting regional administrators who, are answering to, I mean, I'm sorry, congressionally confirmed, Senate confirmed regional administrators, or they're reporting to Senate confirmed personnel. Is there variability within staff? I think 100%. I think there always is variability within staff. And I think that we all kind of know the general reputations of the various regions, and Region 9 is the example here. I mean, no question that Region 9 has a reputation for being more aggressive on enforcement, for example, than some other regions. But I also would say that this administration, both in practice, but also in their affirmative statements, has shown a real willingness for people to appeal staff level decisions up the chain. And I literally, again, I heard this on the DOJ side from Todd Blanche just last week, and it was interesting what he said, because it's a little different than what I feel a lot of administrations say, but it actually makes a lot of intuitive sense. He said, talking about kind of the DOJ staff attorney, assistant U.S. attorney perspective and appealing up the chain, that no staff attorney, whether at DOJ or EPA, should ever be concerned about an entity appealing up the chain to management, because if you're doing your job, you shouldn't be concerned that they're basically going above your head in order to check in with your management, because the management should already be briefed and should already be supportive of the approach. Where the only real concern I think this administration has is about extreme leapfrogging, which, at least I think the stated position of this administration is, don't go from the staff attorney to the deputy AG or the deputy administrator of EPA. Like, you've got to work through the process of going up the chain.
The other check on that, a lot of the policies that have come out, and actually this goes back to even in the Biden administration, a lot of the more policies that contain eggs that could be controversial, the attorneys who are implementing it on the staff side are supposed to go to the OGC and get clarification. So there's an intent to centralize all of this. It could break down in the details, but you'd have recourse.
And hey, hi Steve, thanks for the question too. We'll have to meet up soon.
Well, thanks everybody for joining us today. I think we learned a lot in a very short period of time, which is always our goal with these programs. So thank you, Tom and Mike, for being so well organized and following the PowerPoint slides very closely for the interest of time. For those of you that might be interested, we're doing a program tomorrow, same time, 1 o'clock. That's going to preview the oral argument in the Monsanto versus Darnell case, which is the FIFRA preemption case that the court has taken up. 3 panelists of different sort of persuasions in that. And if you want to register for that, you can go to our website and do that. This program will be available as a recording relatively soon, later this afternoon. So if you know anybody that might want to watch it, please let them know. And again, thank you everybody for joining us today.